I can hear you. Yes. Thank you. Yes.
This regularly scheduled and long-awaited meeting of the Planning Commission shall now come to order. It is September 5th and 5 minutes after 7. Could you please call the roll?
Mr. Waldman,
Present.
Mr. Klein,
Present.
Ms. Butler,
Present.
Mr. Cummings.
Present.
Mr. Chairman, we are not expecting the other two.
All right, we have a quorum and we will proceed. For our vast television audience, I would like you to remain glued to your screens. Beyonce might appear later in the meeting. We have an agenda tonight. Let's see, our agenda is, has everybody read the agenda? It consists basically of a public hearing on an ordinance extending clarifying special exceptions process, and a number of findings on past business that we performed before and during the summer. Are there any additions or corrections to that agenda?
Yes, I would like to amend the agenda to include approval of the July 18th minutes. Because right now it just includes July 11th. We had a virtual meeting on July 18th.
Yes, and we do have those minutes. So with that addition, do we have a motion to approve this agenda?
So moved.
Second?
Second.
All in favor?
Aye.
Aye. All right. So let's go over minutes. First of all, we had the July 11th meeting. Are there any changes or modifications to those minutes? If not, hearing none, do I hear a motion?
I move to approve the July 11th minutes.
Second? Second by Mr. Cummings. Any discussion? All in favor say aye.
Aye.
Those minutes are approved. July 18th, this was a virtual meeting where we addressed a couple of different things. Are there any additions to them?
Nope.
Well, you had the,
Not since she's incorporated them. I
okay.
haven't, yeah.
All right. I'm good with I'll make a motion to approve the July 18th minutes as amended with Ms. Butler's comments.
I don't know what's in red. If I could see yours.
These changes.
I don't know what they were.
What's your-
The red line there.
Okay. Those have been incorporated into the official minutes? Okay. All in favor of, any further discussion?
We just need a second. on that. Mr. Klein, motion.
Second.
All right, Cummings seconded. Any, all in favor of approving those minutes with those changes, those amendments? Well, they were incorporated. Okay, fine. All in favor, say aye.
Aye.
Aye. Okay. Moving ahead, we have a public hearing on ordinance designated as 03323, which changes the deadlines for builders to utilize special exceptions that they receive from the Board of Appeals. And I will now open the public hearing on this and ask Mr. Jakubiec to make any comments that he wishes to make. Now, I do, by way of explanation, we received a series of amendments sponsored by Alderman Chandlemeyer. Has everybody here had the opportunity to read those?
I
Okay.
tried, but it was hard because there were so many different amendments. So I'm not sure I had the whole thing in one document with all the accepted amendments. So yes, I did give it a best shot.
Okay, well, I hope that we get explanation tonight from staff and the sponsor. So, Mr. Jakubiec.
Thank you. Good evening, Planning Commission members. It's good to see you. We have before us an amendment to the proposed amendment to Title 21 zoning ordinance to lengthen the amount of time or lengthen the life of a special exception. Currently, well, first, what is a special exception? And for folks at home, you can start at baseline. There are two types of uses allowed in the zoning ordinance generally. There's permitted by right uses, which is a use that's listed in the permitted use table as permitted. There's no question about whether you can operate that type of use. You obtain site plan approval and a building permit, and you can operate the use. An example of a permitted by right use would be a house in a residential zoning district. The most obvious example. There are other type of uses are called special exception uses. These types of uses require a public hearing, and the Board of Appeals conducts that public hearing, and the board makes a decision, and their decision is based on the impacts of a proposed special exception use on its neighborhood. Now, I want to make it clear that a special exception is a valid, presumed valid use. It's not a use that we just throw in there and put a special exception designation and somehow suggest that it's really not valid or maybe it's less desirable. It's in fact a use that's permitted, but permitted through a different mechanism. The essential test that a Board of Appeals applies is this: does the use at that particular location have impacts that are more adverse than they would be elsewhere within the zoning district? It's really a locational test of impacts. Does the impacts of that particular restaurant at that location exceed what could typically be associated with a restaurant within the zoning district? Which means that the Board of Appeals examines the impacts of the restaurant, in this case, to the adjoining property owners, or to pedestrians, or to parking issues, to fire emergency. And is there something unique about that location that makes this particular use particularly troublesome? And if they make those findings, they can deny a special exception. If they don't make those findings, because the use is presumed valid, the board ought to approve it, just like it would approve, or just like the Planning Commission would approve a site plan for a normal permitted use. So the use is presumed valid, and which is an important thing to keep in mind when we talk about extensions and expirations. There's a sense that maybe special exception use is less than desirable, so we should seek to expire it sooner. But that's not the case at all. It's a use, it's just as valid. It just goes through a more lengthy process, and there's more reasons to potentially deny a special exception use if if the applicant doesn't perform well in front of the Board of Appeals. So that's an important thing to keep in mind. What this ordinance would do is extend the life of special exceptions. Right now, a special exception would have 1 year to become established before it expires. That's the current law. And while the zoning ordinance is not clear about this, we have in practice said established means the use and occupancy permit has been issued. So an applicant has 1 year from the date of getting approved by the Board of Appeals to get a use and occupancy permit. Now, that is almost impossible, nearly impossible in almost every circumstance. So because building permits are complicated, the zoning and approval process, or the building permit approval process is complicated, costly. Things intervene to cause applicants to delay when they can actually get their use and occupancy permits. So the code now provides for 2 6-month extensions. The Board of Appeals can grant up to 2 6-month extensions. So effectively, you have 2 years if you exhaust your extensions. You have 2 years from the date of approval to the date of occupancy. In those 2 years, you've got to deliver the project. Still, that's very complicated and almost overly optimistic in the real world. And as an example, not long after I began in September, I was confronted with a special exception that was running up against this tight deadline. And the issue was that there were a number of issues, but there were specific building permit issues that the Board of Appeals could not have anticipated, the builder could not have anticipated. Like the hood in the kitchen, which is a major cost item, was on back order because of COVID. The things got backed up and they couldn't get it, and they can't get a use and occupancy permit until they get the hood, which is essential to the fire protection and the life of the kitchen. So there's a very practical reasons why some of these special exceptions can't get occupied and opened in 2 years. The proposal would lengthen this time a bit. It would extend the initial life of this special exception from 1 year to 2 years. And it would allow the Board of Appeals to grant up to 2 1-year extensions. So now we effectively have a proposal to extend the life to 4 years. Of course, the Board of Appeals will have to make a finding of good cause in order to issue an extension, but they can move to 4 years. And there are other aspects of this proposal that we can ferret out and get into more details. And I would expect that the applicant would kind of carry the weight on those things. And I could support the Planning Commission and ask questions to the applicant if it would help, or make comments to you at the right time. But in the essence is that this extends the life of the special exception to 2 years and grants 2 1-year extensions.
Can I ask a question?
For a total of 4 years.
And that's this Amendment 1, not the original first reader. Is that?
That is embodied in Amendment Number 1.
Amendment.
That's right. My comments are reflected on Amendment Number 1, which is essentially a wholesale amendment.
Yeah.
You know, it stands alone,
yeah.
right?
Understood. I just want to make sure we weren't talking about the original first
Right.
reader that we saw however long ago.
And if I can, by way of background, this bill, the original, was placed before you, and the Planning Commission considered it. And I believe you were inclined to give a favorable recommendation, but when you reconvened at the next meeting, the chair said, we're going to take more time with this. We'd like to schedule it and reconsider this, which I really appreciated because it gave me time to talk with our assistant city attorney to ferret out some of the issues that I had with the draft that I didn't know about going into that when you went into that initial meeting. And so I wrote that more lengthy staff report. You might remember I talked about examples, and I gave a little, like tonight I gave a preview or a review of that staff report. The sponsor responded to my staff report too by considering changes to the draft, and actually met with me and submitted the draft through the Office of Law, the draft writing staff. But I didn't get that until just last week, and I haven't had time to do a formal staff report. So that's why I'm here in person tonight to talk you through it. Which is to say that because this is an amendment, it allows the Planning Commission to delay action on this for 30 days. So you don't have to decide this matter tonight. And of course, your decision is a recommendation to the City Council, just to be clear. You can revisit this at the next Planning Commission meeting and formulate and decide on the recommendation then if you wanted to. I just wanted to make that clear to the commission members that you don't have to act tonight. If you feel comfortable with it, fine, but this can be discussed again and still comply with the notice and the timeliness requirements that City Council has set forth in Title II of the code. So we can take more time if you had to.
So can I suggest that, so we have this version that has Amendment 1 that was sent around, and there's actually two versions of it. One, there's Amendment 1 just alone, and then it has Amendment 1 with all the original language, the update. So we can see it sort of in the cleaned up form and what's changed from the original, what's the current law. I mean, first of all, I think it's laid out much better. I think it's much more understandable in A, B, C, and D. It's very logical. But if it's okay with everybody else, if we could go through the four situations in Section B of the expiration of special exception not established, just so we're all clear on what it says. Does that sound reasonable to you guys?
Yeah, I would also, I just have a question based on the last staff report, and maybe it's addressed in here and I didn't see it. The last staff report mentions that the proposed legislation provides no standard for the board to apply when deciding whether to grant an expiration. The current code omits a good standard as well, or two. But if the extension period is to be lengthened, then it is especially important to provide the board a standard to consider when faced with an exception decision. The standard we like is something like this, and then you say, the board may approve an extension upon finding at a public hearing that there have been no material changes in the neighborhood which would impact the original approval or any conditions of the approval then imposed. Is that suggestion that you make in your staff report contained in this amendment?
Only with respect to paragraph 4. So I can dive in a little bit deeper then. Paragraph B has 4 specific sections. The 4th section says that even after the board has given extensions, and it can give up to 2 extensions. After it's given the extensions, the board can consider another request for extension. But this time, it has to apply the strict standard that's set forth in Maryland case law for what makes a special exception legal. Just an aside, there are a lot of standards in our code about special exceptions. Mm-hmm. They're all important, but they're not as important as the case law that says the impact of that special exception at that location can't be more adverse than the impacts generally associated with uses. So that locational test is what's embedded in state law. And those standards in our code, the criteria, ought to be employed to operationalize that legal standard, okay? It doesn't always work out that way, but effectively that's what's happening in the law. We are trying to operationalize that case law standard. So what item 4 provides for is that strict standard then becomes the rule of the day. If someone needs another extension beyond the 2 that they've already requested, they come here, and essentially that means that the board is conducting kind of another hearing, right? Mm-hmm. Now it's kind of a light hearing, mm-hmm. a hearing light, because the applicant is not asked to meet all the criteria, but it's asked to meet the fundamental legal criteria, which is not candidly an easy.
Yeah, so it basically, it looks at the context and says, is anything really different here? If we let this go for another year or something like that, has the area really changed or not changed? So what's another year? Basically, is what it says.
But it's after 4 years that you get to that kind of.
You would get to that after 4 years.
Yeah.
Now,
that's after the 4 years.
Right.
So,
right.
Yeah.
Right. So the first, 4 years reflects kind of the reality of the complexity of building and getting permits and things like that. That's a judgment call, whether you think 4 years is right or not. It's probably right. I mean, in practice, and I think the sponsor can speak to actual experience more than I can because I'm still relatively new in the city. But after that 4 years, then the legal test comes into play. And as you consider whether that's vital to your consideration here. Think about whether that special exception use is in fact a valid use within the district. And again, there's been a legislative decision made. The city council could have made restaurants unpermitted, not permitted within certain zones, but instead they said, yes, they're permitted, but by special exception. So they've said they're okay. We're okay with the impacts generally, noise, lights, pedestrians, traffic. To some extent, that's part of life in a commercial zone where we allow restaurants. So they've said it, but we want a detailed test of those impacts, and that's why there are special exceptions. So when you consider whether, 4 years is enough, I think it's worthwhile considering that they're not too different than a by right use in reality, right?
So if
the
I
one
may,
question- oh,
so in walking through section B, number 1 is basically 2 years. Number 2 says, okay, maybe 2 more 1-year extensions. And then 3 says, okay, 4 years, it expires. And 4 says, this location test after 4 years, maybe. That's basically the way that all reads
Yes,
in sort of simple language.
yes.
Yeah, I think so. And
mean,
the
it's-
only question I had, and we brought it up first time around, was that if the law changes, so not just material change to the circumstances of the use or, the neighborhood, but if there's a substantial change to the law, be it environmental or anything else, there could be a new code provision that talks about fire and safety. Wouldn't we want the applicant, after at least 2 years, to meet the current standards of our code?
Well, it's really no different than a by right use. If the law changes before that use is pulled a permit, it hasn't obtained vesting, so it has to meet the new law. So in this case, if the applicant has not pulled a permit, the applicant is not vested and would have to comply with new law. But if the applicant has pulled a permit and started construction, they have vested in the approval. And then they're immune from the changes in laws most changes in law that would affect.
Well, can we look at Rocky Gorge, for instance? They knocked down all the trees. Gosh, it's more than 5 years ago. And nothing's, been happening, but they can say they're vested because they knocked down all the trees. Are they going to say now, we're not going to have to follow the updated Forest Conservation Act? I mean, that doesn't
Yeah,
sound
but that's
like.
not a special, that's a different.
That's right,
it's a
that's right,
different thing.
development,
It's
but
not
that's
a-
just
it's
my
not a special
example.
exception.
But what if it was a special exception? Or I'm trying to think of a special exception that would work in that situation. Should the law changes with respect to something that's important? So it's really not the locational test and the material change in the neighborhood, but it's really, the law has changed, and now we want to make sure that everyone's complying with the law.
Yeah.
I would say in the first 2 years, that's hard to do because you're right, it takes a little while to get up and running, and you can't really hold it against somebody that the law has changed. But after 2 years, would you think that would be a good idea?
I can only talk about it. I don't have a definitive answer to that, really. If a project is in fact vested, it doesn't matter so much what I say about it. I mean, it's vested in its approval. It ought to be able to move forward, just like any other use. If it's not vested, then it's in this gray zone where it would have to comply with the laws administered at the time that a permit was filed. So, I
I don't see the words talking about vesting here, and the example I gave was not a special exception example. So maybe we could walk through how that would look with vesting and special exception, because I'm curious to see.
Well, I think you did mention, you talked about the vesting with respect to permits. So if you've got a building permit, once you get the building permit, if the law changes on something under the building code, you've got the permit, you're bound to the law at the time that permit was issued.
So why
Well,
wouldn't anyone that
it's-
gets a special exception just pull the permit immediately and then just sit on the
Because
permit?
not everything
Well,
is,
it's not just pulling the building permit, it's also moving forward with some substantial construction. So
Yeah.
So
that's
the
what
language,
vests
yeah,
a
that's what
project.
vesting has to do with, is
Yeah.
substantial construction. You can't knock down the trees and say that's substantial construction. I mean, no, that's the bad example because it has to do with development.
Right, so if in fact that project or any subdivision
Right.
were a special exception, or say it's a multifamily, and they removed trees because they could, and then the law changed, before they actually poured a permit for actual building, they would not be vested in their project yet. They've gone ahead to do some development activity because they have an approved plan, but they've not pulled a permit and actually put footers in the ground or made some kind of measurable direction towards constructing it. So they still are vulnerable to legal changes, code changes.
Yeah, I would think so, but I think our
Yeah.
last in-house city attorney didn't agree with that, and so that's why I'm curious about the vesting.
Okay.
So it doesn't say anything about that. Number two. It doesn't say anything about complying with any changes in the law since the grant of the special exception in number 2. Doesn't say anything about that.
Right.
So I think Ms. Butler's question is, why not make that explicit? Follow me?
I do follow you.
Okay, because then they've now gotten 2 years, and things are changing. There's no doubt, things are changing. And
And sometimes more favorably. So maybe parking requirements will be easier.
right, stormwater management may become harder, whatever, but, pedestrian access may be changed, but there could be changes in the building code or existing whatever's local law or state law after 2 years, and they have not gotten, they've gotten a building permit within the 2 years, okay? But they can then get an extension of up to 2 more years, right? During that extension period, should they not have to comply with any changes in the law?
No, but in B, that's the special exception not established. So in B2, that's you've gone 2 years and you still don't have a permit yet.
No, that's not the way I read that.
No, you can have a permit very quickly. So it's possible you have your permit, but you just have not established it through getting a use and occupancy. You've not completed the
Oh, I see.
So the
project.
establishment is the
Is the use
use
and occupancy?
permit.
Yeah, it's the use
and
permit.
occupancy permit.
No.
No?
Yep, yeah,
Yeah, that's when the special exception's established.
Okay. So it's the period between, practically speaking, between a building permit and a use permit, possibly.
or it could be
No,
between
it's
the
only if they
approval.
ask for an extension.
So between the approval of the special exception and the use and occupancy permit,
Well, the use permit comes quite a bit
Yeah.
later.
Yeah, it's at the end, when you're done.
Maybe we can hear testimony too from the applicant about this, but the most important thing to consider here that I've seen is it's what happens between the time that an applicant pulls the permit and starts construction and then actually getting the use and occupancy permit. It's no one wants to hesitate getting a permit. Once they get their special exception, they want to get to the permit office and get their permit. Things get complicated when you're doing construction and outfitting a use and all that's involved in that development activity. And typically, someone's going to vest their approval as quickly as they can through some initial construction. And there are all kinds of code provisions in Title 17, the building code, that provides mechanisms for enforcement and for keeping permits on track. If a permit stalls and it just doesn't go anywhere, the building official has the opportunity to intervene, to void the project, or to otherwise take enforcement action. So it's generally speaking, things bog down in that process of between permit and use and occupancy. And that's what this set of standards really allows for. It lengthens the time when you're in that stage of actual development, when funds have been expended, when investment has been made, when all the construction activity is underway, and all you need is that use and occupancy permit, but it's taking you a long time to get there. So I don't know if that answers the question about whether to put a legal change in there or not. I might be, bumping up to the edges of my expertise on that, because it's some legal issues there, but I don't know candidly if it's necessary, but I'll leave it.
Well, in general, with things that aren't special exceptions, after approval of a project, before building permits are issued, if the law changes and then the building permits are issued, whatever those changes are have to be performed when the building permit's issued. If the building permit's issued and then the law changes, they don't have to make those changes if they already have the building permit, right?
The building permit is issued and construction starts in a meaningful way.
In a meaningful way. And in
Right.
this case, Gary Ellison, our previous lawyer, said that construction did include knocking down trees. And then that seemed odd. But, I'm just trying
Well,
to.
I guess my
language.
point is, if this is a bigger problem that transcends what we're talking about here with special exceptions, let's not try to fix it here. If that's if that's like a bigger problem with when does construction start, that's.
Well, I just wanted to be clear here, what we're talking
Well,
about.
I mean, I'm trying to not get balled up in having the law say one thing in the special exception case and having it sort of say something different in the non-special exception case, because we're trying to fix a bigger problem, but only changing one place and not the other. That just starts to get into this, one of the reasons we have this Byzantine mess that we have, in that I guess I would be more willing to leave it a little bit nebulous just to keep it clear, and then hopefully somebody who introduces these things will look at that bigger picture and try to fix that problem of projects being sort of zombie things, that somebody stirs a little dirt or puts up a 2x4 and says, okay, we've started, and started the clock. But that's a different story here, and I'm just really trying to not complicate this discussion with trying to fix that here. I recognize it can be a problem, but
I don't think it'll be solved.
but having it quote fixed in the special exception case, but not fixed in the general case, that seems to be creating another problem that makes that problem worse rather than better. Just an observation.
And then we go on to cessation of the expiring special use. If the, so it can expire if the use is not continued. They close the restaurant and it's closed for a year.
Yeah.
And then the Board of Appeals, simply in its discretion and good cause shown, may grant up to 2 more years.
Right.
So you have properties which can be sitting basically, unused, and things changed around, and you do not have the same legal standard that's further up in B4 apply in the case of an abandoned use or an unused use. It's abandoned after a year.
Yes.
Okay.
Yeah. Would
you think that would be wise to put the same language in to D2 that's in further up in B4?
No, not necessarily. This is when a use that has been operating goes out of business. Say it's a restaurant and goes out of business. And it takes a year for a new owner-operator to move in. If they're going to operate the same way, under the same terms of the original approval, shouldn't they be able to operate? Because it's the use that's important. Just like a by right use, if it can go out of business for a while, but a new owner can come in and start the business. That's what this says, is that use can continue.
Well, let's go back. What you said was that over a period of time, things can change.
Right.
And that's why that higher, stiffer standard is in place after 4 years.
Right.
So why not the same situation? You have a restaurant which is there and has been a problem, let's say, and then it's not used for a year. Why not impose the same kind of a standard that, well, it's not amenable. It's with the surrounding zone, probably residential. Why not put the same sort of a standard in if somebody has abandoned it?
Well, to answer that question, I'm not going to argue the point, but the one logical answer to that is that how would someone feel secure in their property rights knowing if they took time off to sell the property and had to shut the restaurant down due to the death of the family or something, that their right to operate that restaurant or other special exception would go by the wayside, that they would have to come back and go back to the board and get a new hearing for a use that has been operating there and has had the effect of defining what the neighborhood is because it's been operating legally. So you might argue that it could place a cloud on one's ability to protect their property rights.
Well, how about the people who are surrounding this use? They've been putting up with something that's, for all of these years, and now it's going out of business, and now they have the chance to say, no, this doesn't fit here. A tire repair shop doesn't fit here.
If the use is operating beyond its approval, then it's a code enforcement issue. And that's where that would settle. But once a special exception has been approved, it's presumed to fit in the neighborhood. And as long as it's meeting its obligations under the conditions of its original approval.
Well,
that's the answer to your question.
Well, I understand that there's a property right, but there's also, people's residential rights, so to speak. And that's probably the conflicts which are going to arise.
Right.
And yeah, sure, the tire repair shop may be operating according to its conditions that were imposed 15, 20 years ago, but times have changed.
Then the answer is to amend the zoning ordinance and eliminate tire repair shops from that zoning district.
Yeah, but that's a monumental task, whereas here you've got, fluid situation. New owner wants to come in, wants to find out if he can operate the tire repair shop. I don't know. You know what I mean? It just says Board of Appeals, discretion and good cause. What is that? Doesn't give them much to go on. So I'm thinking that there should be some form of stiffer standard that applies also to the cessation, or is that the word that's used? Yeah, cessation of an abandonment of a special, or unuse of a special exception use.
That would, if you wanted to restart a special exception, you'd have to meet a higher standard. The board would have to evaluate it more comprehensively than simply finding that there's good cause.
That's certainly the simplest way, is say restart it.
Well, use the same language you use in B4, that their location would now have adverse effects above and beyond those effects inherently associated with the special exception. Use the standard material.
Thanks to the Court of Special Appeals or whoever wrote that language. It's got more negatives in it than I can
It's not
imagine.
easy to understand.
So it should be either a stiffer standard or restart the exception process. That's my note. All right. Okay. And no more question, any more questions of Mr. Jakubiec at this time? Okay. So I will now continue with the public hearing. The star of the television there, Mr. Shandelmeyer, has been waiting very patiently. I understand he's got other obligations and he's taking time out from them. So let's hear from you, sir.
Thank you, Mr. Chairman. Thank you, Director Kubiak, for a really good breakdown of the amendment process. Just kind of where I'm coming from with this is as the construction industry continues to get more chaotic due to material shortages, labor shortages, increase of costs, fluctuations with interest rates, etc. Making our special exception process more flexible can be incredibly beneficial to projects that will be a value and an asset to the city. I think Director Kubiak got into the language a lot better than I could, him knowing this stuff front and back, but the goal is just sort of increase flexibility for some projects and make a very visiting process a lot easier to navigate.
Alderman Schindelmeyer, do you have any problem with making sure after 2 years that the applicant comply with current code? Any code changes?
I see it as a apples and orange thing. If there's a larger issue with lack of compliance, I'm happy to tackle that for another thing, but to apply a different standard with special exception versus by right is a little bit irrelevant to me. I'm not aware of any massive problem to it at this time, so.
But just to be clear, if the person has already gotten the building permit, he's vested at that point. I think that's a good term to use. It's not used in the amendment, but it's a good term to use in that you can't then force him or her to comply with new things before they got the permit, the building permit. Follow me?
Right.
And so, but I understand the concern that if it gets lengthened out to, 3 years, 4 years, things do change. And they've gotten a building permit, but for whatever kinds of reasons, they can't continue. They've run out of financing. They've gotten, I don't know. So do you understand, Mr. Schandelmeyer, the conflict here?
I guess I think Director Kubiak's definition of vested made a lot of sense to me. I don't know off the top of my head if that's in the code currently or not. Look, things should comply with things, but I really don't know. I have no opinion on the issue. I just don't quite see the relevance for what we're trying to do here.
Okay.
If there is, I understand what Rocky Gorge or whatever's going on with that development had some weird issues, but I don't see that as part of the special exception process. It was part of the plan development.
All right, let's say there's a sprinkler amendment that says, or new code section that says you have to sprinkle a house that's been approved by special exception in 90% of the house, whereas before it was 50% of the house. I don't know, just like some health safety issue. You're saying here it is 4 years out and the special exception, the permit was issued, they're not done building whatever the restaurant or special exception for a house is. They don't need to comply with that safety requirement that's changed in the law?
I believe we already require sprinklers in family
No,
units.
that's just an example. I'm trying to use something like a safety issue that may be updated because our city has said, we've had a couple of fires where we shouldn't have had. So now we're changing the code to make it a little more safe for the occupants of the building. And you're saying, well, we don't really want to hold them to the new standard because...
I am not aware of any issue where that's come up, and my hesitation behind doing that is I think we've put forward a lot of well-intentioned regulations and rules that have ended up having a Goliath later on. And so I want to try and keep this as simple as a special exception can be. It's already an overly complicated process. I want to try and keep it a little bit simple. If like for example, there was something allowed by right and they hadn't started the construction process, they hadn't gotten their vested in, and these new rules and regulations come up, then yes, absolutely. But if you're, say, 85, 90% done with the building, a new standard comes out and you're having to suddenly scramble to do a lot of potential retrofitting, that ends up killing.
So vesting versus 80, 90% finished. I'm just curious. Okay.
But
I mean,
all that's
there are
covered in
millions
Title
of-
17, right?
Yeah,
So
So
if you have
there's-
to actually increase the amount of sprinkling you do in a unit or a building, and that changes, that will be covered. The law will basically say you have to, by the time you're building it, keep up with the current code. That's what you're saying. I just want to understand that. I think that's what
Well, if
everyone.
you're not
I'll let
vested,
Director
you do.
Kubiak.
If you're vested, you don't. But all that's covered.
But there's
in
no
Title
wording
17.
investing in any of this language, which is, that's a little bit concerning.
Well, it's just a word.
Okay. But how do you apply it? That's all I'm saying. I'm just curious.
When the building permit is issued, okay, it's issued according to the plans which have been submitted and approved.
Right.
And then you can't change the game afterwards.
Even after 2 years, if the building code changes, you're saying, we're not going to make this to meet the current safety code section.
Well,
I'm fine with that. I just wanted to know.
wait, there are situations where 0% or 1% of the construction has occurred, and there's situations where 99% of the construction has occurred. And so you can't just make it a blanket rule that they have to tear out the ceiling and put in more sprinkler pipes. You just,
Mr.
you
Jakubiak,
can't
can
by
you-
fiat here. It's
Yeah.
like,
Can you just explain
Yeah, maybe I.
when vesting happens again? What the wording is investing? Because that's what we're getting all balled
Yeah,
up
it's not
here.
in our.
it's just a
code.
word that, but
But it's
Yeah.
the building permit plus, what is it, substantial start or whatever the,
Just substantial construction. Usually it involves constructing a foundation and moving forward with some type of construction.
Right.
With the,
okay,
with the legally obtained permit. It's valid. And
okay.
but
Substantial
that's all
construction.
handled in Title 17.
Yeah, if it's
well,
something,
it's not, the term vesting is not, doesn't permeate our code. And there's nothing in discuss vesting in the context of permitted by right use either. So introducing it here at special exception kind of complicates things.
Yeah, that's what I'm saying.
It's a principle. It's a legal basis for property rights. It's what helps move the system along. The principal concern that you would have, the more typical concern would be a change, not to the building code so much. It would be a change to the zoning codes that said, for instance, that that particular use is no longer allowed, even after you've got your approved special exception, or that now you have to do twice the number of parking spaces than you previously could. You could see how that would totally deconstruct a project, would make it impossible. So vesting kind of protects an applicant from those types of zoning changes. But it's a principle of development law that permeates the approval process. I don't know that the word vesting shows up in our codes anywhere.
but substantial construction seems like a good phrase that captures what you're talking about. You really want to be like, the applicant has done substantial construction and the law has changed, and that's, there's no way that they can backdate their, or, redo their plans to meet those new changes.
Yeah, that's basically the principle.
I have another, are we done with this?
Yep.
Mr. Schandelmeyer, I have another question. With respect to this cessation of the special use, if the use has not been used for a year or more, it ceases, right? Okay. And as we just had this discussion before about how there can be changed circumstances over many years, and including that 1 year, why not ask them, because to go back to the Board of Appeals for its location-specific decision-making? It's not that much of an inconvenience. What do you think?
It can be an inconvenience. The more you have to go back to the Board of Appeals, the more you have to go back and do these various extra steps. I think it frankly benefits lawyers more than actual city design and benefiting of things. Restaurants is your example. I've worked in restaurants that have shut down after about 4 months just because it wasn't the right concept. Took a while to get off the ground, and when they were able to, it was a hit. And I think the more steps, the more hurdles that you put in, the more potential barriers that you get, the more intimidated people get when they try to go for a project or an idea or some innovative thing to start up, to go forward with. In the example of if a restaurant was having lots of potential conflicts and issues that were in violation of code, well, we can address that through code enforcement. We can address that through fines. We can address it through other things. But to just go, no, we had the last restaurant owned by John Smith as a problem, so you, John Doe, can't do this, even if it's an entirely different concept, an entirely different idea, an entirely different vibe. It's just extra things to go through that can stop John Smith, owner B, or whatever you want to call it, to innovate, to be innovative.
You're speaking from the viewpoint of the business owner, the entrepreneur, the restaurant owner, the tire repair shop owner. There are residents who often surround these operations, and we need to think of them as well, and how do we balance that in a way which is logical, straightforward, and gives an opportunity to perhaps right some wrongs that have been in existence for a while.
I think we can do that through code enforcement or through actual changing or text amendments in the zoning code itself. The more, though, we try to micromanage, come up with the perfect solution in a very complex system that is urban planning, neighborhood building, the more likely we are to just end up creating an overbearing process. So that's my issue. I just think the simpler, the more flexibility you give, the more likely we are to actually get something that fits in, that meets the needs, functions. And if, for example, if you have something smack dab in the middle of a neighborhood and it's ticking off all of its neighbors all the time, there's no redeeming factor. So that business probably isn't going to thrive. That business probably isn't going to last. What will last is something that works in this. So I'm just kind of, I just think cutting down on that flexibility makes that less likely.
Well, okay.
Mr.
My
Chairman?
experience has been different, but okay, we'll continue. Anything further with Mr. Chandlemeyer?
I think Mr. Jakubiec has.
Hey, Mag, I just want to make it clear that, so the commission knows this. The current code says that you have 6 months. Once the operation ceases, you have 6 months before it expires. A special exception expires if it ceases for more than 6 months. So what this does is extends it to 1 year, but then it creates 2 possibilities for extensions. So one way to address your concern might be to lengthen or reduce that overall time, if that's the issue of, like, passage of time changes things. That is a possibility to consider as well. Rather than making an applicant go through the process again for reapproval.
Okay.
Yeah.
I think that there's probably a balance, also known as a compromise there. All right. Since nothing further from Mr. Chandlemeyer, we do have one live person who wishes to testify. Sir, could you identify yourself?
Yes, Mr. Chairman. Phil Dales, Dales Associates, Land Use Law, 238 West Street, Annapolis, Maryland.
Proceed.
So I came tonight planning just to provide some context, to hear what the director had to say about the proposed bill, and then offer some context from the real world special exceptions that this would affect. And for context from other jurisdictions like the county and other counties that I've practiced in. But I listened to what the director had to say and thought that everything he said in his introduction about what special exceptions are legally and why this is being proposed was accurate, and I didn't have anything to correct at all. The context I was going to provide just quickly, because I think my time might be better spent discussing the 2 issues that you've raised in your questions, which are, in my opinion, extremely interesting and relevant questions and issues for a special exception context. But before I get to that, I'll quickly just say that, in the county, for example, when a special exception is approved, if a building permit or grading permit is issued, it no longer is going to expire. That's it, full stop. So any version of this that you're discussing here, where even after the issuance of a building or grading permit, there might still be an expiration, would be a stricter law than we deal with in the county, as just one example of a jurisdiction that has a different rule. The intent here, I believe, was to make our expiration provisions more similar to other counties, because they're becoming problematic as construction becomes more complex, our laws governing construction become more complex, and I think that's all understood, it sounds like, from the discussion here. With the questions you've raised tonight, the first one I think I want to just give some quick legal background, and of course anything I say, you can check with the Office of Law or do your own independent research, but I just argued the issue of vesting in an appellate court case recently, and so I had a brief here with the definition of what vesting is in the Maryland courts. It's a legal term. It actually comes from a constitutional standpoint that once you have invested physical investment into an approval, then you have property rights in that approval. And so there are 3 criteria. The first is that there must be an actual physical commencement of some significant and visible construction. 2, the commencement must be undertaken in good faith, to wit, the intention to continue with the construction and carry it through completion, not just I did something so now I invested for show. And 3, the commencement of construction must be pursuant to a validly issued building permit or permit. So
Can you repeat number 3?
The commencement of construction must be pursuant to a validly issued permit. In that case, it's building permit, but it's permit. So the idea of vesting, rather than considering the example that was raised by Commissioner Butler, which is, I think, a good way to start thinking about this through example, but that one is, I think, maybe a difficult example because of the opinions issued about whether grading creates vesting or not. Let's consider an obvious example of vesting. Like the most obvious one you can think of is a building half built and they run out of money and it sits there for 10 years, half built. That happened while I was living in Charlottesville. It was a big problem in the city. People hated this building. It was a real safety issue, but it had vested its rights. And so if a building vests its rights, then it's not subject to changes in the law. For example, for maybe new sprinkler codes, if it was approved prior to that law being applied, right? If you wanted to go and change your approval, that request would be subject to those laws. But with what we're looking at here, when we're talking about special exceptions, this vesting issue does become really interesting because unlike a permitted use where you really are barred from making those laws that change, and I think Commissioner Butler's question is specific and narrow, that when we're talking about this 4-year example in Part B, I think the suggestion was, shouldn't the requirement, in addition to proving the neighborhood has not changed, also require that the law hasn't changed? But if the law has changed and they have not vested, which again, you don't vest by getting a building permit. That's not vesting. So you get a building permit, you haven't started construction, you haven't vested, the law changes, you have to comply with that law for sprinklers or whatever it might be. But if you have vested your rights and you now have essentially a constitutional right to those approvals, you're not subject to it, whether it's a permitted use or a special exception. But with special exceptions, you have an opportunity, as the council, not really the planning commission, but planning commission can suggest to the council that in the case of special exceptions, if the law changes, not after vesting, that's not within your power or the council's power. But if you've gotten a building permit, but you haven't vested, or you haven't established your use, the special exception can expire, just like it could for an existing use that's been operating and has its use permits. If that construction stops for longer than some period that you would recommend and the council would approve, then you could take that special exception away. And although they may have vested rights, they could run out of their special exception the same way an existing prior special exception use could. But I think you should choose that time frame thoughtfully, that if construction is happening, it delays or market changes, and you want to make sure that it expires or becomes governable by changes in the law, that pause in construction should be a significant pause, at least I would say, beyond this 4-year period, another year or something that puts people on notice that they're about to lose their vested right because you're going to expire their special exception. You can deal with the issue, is my point, that if you want to make special exceptions different than permitted rights before they vest, it's a very narrow situation. It's after getting a building permit where you now aren't risking the loss of your special exception, but you haven't started work yet. You could deal with that, but I think you should deal with it thoughtfully if you choose to recommend that. If there are any questions, that I can do my best to answer any questions on hypotheticals or examples on the question of vesting and special exceptions. The other issue that's been raised is what happens to existing uses, like the tire shop that's been around for 20 years, and now maybe even the neighborhood has changed, right? But they stop use and they get that 1 year of period to find somebody to buy the shop. In a lot of cases, these are heartbreak stories, and I've dealt with this a lot in the county, where somebody's family business, the generations change, and that's all they have is the business, but there's no one to run it. And so they're trying to sell it to somebody who will buy the shop, and it takes them more than a year to find it. They end up asking for, and a lot of times liquor licenses, for example. They've been sitting vacant, and somebody does not want that bar in their community anymore. So they're hoping that they don't find a buyer, whereas the business owner is hoping they can. I think that expiration clause, 1 year, it's some amount of time, but giving the right to come back to the council and say, here's why we haven't been able to get that business started again to preserve it. Good cause is a pretty familiar and typical standard for boards in these situations to grant discretionary extensions. You have those 2 years in this proposed bill. That's all that's really changing. But the suggestion that you could also apply this neighborhood change standard there is relevant and fair. I think just as it's applied in the first part, if it goes beyond those 2 years, it would be fair to say, at that point, if you've got a tire shop that's been out of operation for 2 years but you've gotten the extension, if you want to go further than that, maybe it makes sense. Come back to the board and show them that the neighborhood still, it hasn't changed since, and I would suggest cessation. Since the time it stopped operating, has there been a change that would say that now we shouldn't allow it to start up again? But it is sort of a life or death situation, or a very, very much an existential issue for a lot of families with small businesses that go out of business when they look for buyers, and the community around them have valid needs, and I think the chairman made this point twice. We should be thinking about them too, but I think the standard should be, if it goes beyond 2 years, you come back, you should have a chance to show the board that the neighborhood has not changed since it went out of business, and therefore we should, at the discretion of the board, be able to keep it going a little bit longer. So those are the two issues you raised on vesting, and what can we do with special exceptions different than permitted uses. And I think it would be fair to add something to this bill to say that if you've gotten your building permit approval, no longer at risk for special exception expiring, but you haven't vested, which again, that becomes, if you've vested your rights, it's a different issue. But if you've gotten your building permit and construction has ceased for longer than a certain period of time, you could add something to this bill to address that and say you got to go back and deal with any new changes of law. I'm sorry, I said that backwards. If you vested, but you're dependent on the special exception, so you're beyond the 4 years, you've got vested rights, you could still take that special exception away, but I think you would want to have a significant period of time where construction had stopped before you did that. And then on the issue of existing use that's long running, I would just say give that applicant also the opportunity to go to the board and show that nothing's changed since the cessation. My thoughts on those two issues.
So let me see if I can summarize my understanding. Thank you for your explanation of vesting, because my understanding before you spoke was that it vested when the permit issued, but that's not actually the case. You really need to do something.
Right.
3 factors. Does this make sense? I'm going to propose 2 changes to that section. Unvested permits, they haven't vested yet. They've gotten a permit, but they haven't really started significant construction, must comply with changes in the law, let's say unvested after, I don't know, 2 years of the granting of the use exception.
That would be unnecessary. Unvested permits already will have to comply with changes in law.
Okay,
It's only vested permits. That's why I corrected myself at the end. It's the vested permits that if they are dependent on a special exception, if they're permitted uses, you'd have no ability. But if they're special exception, you do, because you could take away their special exception. So it would be vested permits that you'd want to focus on.
okay, so then it's really the pauses in construction.
Right.
Okay, pauses in construction of more than X years, and I'm going to ask you to give me your opinion on that, must comply with any changes in the law.
I mean, we've seen a lot of different conditions in trying to implement these types of approvals over the last 10 years with COVID and construction prices changing. When I was working more in the Arlington area, steel prices went skyrocketing and a lot of projects just stopped because they couldn't afford their materials. And COVID did that. Thankfully with COVID, there's a lot of special help. But I would say, construction pausing for more than, this is off the cuff and I'm not a construction person, I'm just a person who works with guys who do that. I'd say 2 years would be an odd gap to have something sit there with nothing happening for 2 years. Maybe that number should be 3. I'm not the best person to ask what that number should be. If you have to change contractors is another thing I've experienced, but some significant period of time.
Okay? Moving on to the cessation or of the use. A use which has ceased for more than 2 years. So in other words, it ceases after 1 year, and then they've got a 1-year grant under discretion, okay? And then after that, must reapply for a special exception subject to the standards that we discussed before.
The neighborhood change standard?
Yeah,
Yeah, that would be a compromise position. I think that where to put in that standard would be a question for the council. But I would say at some point, the first one should be good cause, and at some point, the years are,
Right.
To show that standard. I think the key, Chairman, would be not a change from, when it was granted potentially 30 years ago, because every neighborhood's changed since 30 years ago. But whether this use that we're talking about hypothetically was a part of the fabric of the community. Some people probably loved it, some people probably hated it. So I think the point at which you judge change from is the key. And to me, the fair thing would be change since it stopped operating. That's just an opinion.
okay. Any further questions of Mr. Dales?
No, that's great, thanks.
Okay,
I
thank you,
have
sir.
one quick question. You were mentioning the case that you were talking about that talked about vesting. What's the name of that case? I'm just curious.
The case that I cited, there are a few. The one that I was just quoting was Evans v. Burns, cites 401 Maryland 586.
401 Maryland,
586. Another one,
Evans v. Burns.
Burruss, I'm sorry, Burruss. And then another case is Town of Sykesville v. West York. The abbreviation is communes, but I don't know what the full word was. And the site for that is 110 Maryland App 300. Oh, and one more. Powell v. Calvert County, 368 Maryland 400.
All right, which is the best one?
I think the first one I said, I wrote this a few months ago, but I would say Evans v. Burruss is the first one I cited, so I'd go to that. They probably all cite each other.
Thanks.
It's good. Good. All right. No written comment, nothing further. I will now close the public hearing. All right. Very good. Discussion?
I'm good with what this says right here. I really don't see any real problems. I recognize that we've got several things that we spoke about, but I really come down on what I think I understood from Alex over here speaking when it comes to a lot of these, what the timeline is for vesting and such. That should be handled kind of in the general process and not through this regulation. So what I've seen before with ordinances is when we try to fix it in one spot and not the general process, that you then get a more convoluted situation that you have to navigate, or the end person has to navigate. I'd rather keep this kind of as I see it here, and then if there's we want more clarification on vesting and when the timeline changes, that should occur separate of this process, and it should be inclusive of both the by right as well as the special exceptions. That's what I come down on.
Yeah, I would agree with that. But with respect to cessation, that's a tricky thing, because we all know the game that can be played there, and we can cite some examples around the city where a place has basically ceased operating, but they're open once a year to just to keep the clock running. And so like anybody whose special exception ceases is just not paying attention in a way, because you know how to get around that. But I do like what was talked about here, basically saying that after some period of time, applying this place-based test, I think is a reasonable compromise.
Apply the what test?
This place-based test. This higher standard.
You mean at some point, if it's not been used?
Yeah, so you have the year plus a 1 year extension, then perhaps that's
Then go back to the Board of Appeals.
That's the time saying, hey, what is the context still the same?
Right, the neighborhood change standard should
Because
be
we
applied.
we do have to, I appreciate Alderman Chandlemeyer's comment about not preventing things from sort of moving on, but the flip side of that is preventing things from moving on in a good way. It's like you don't want to tie a business's hands, like, because they can't get started up again, but at some point the tire shop may be not appropriate for what the neighborhood's like now.
Or an auto repair facility.
So I think you have to have some sort of compromise that prevents both kinds of inertia from happening.
Mm-hmm.
Okay.
Something just keeping going beyond what's appropriate, or steamrolling something. So I like that idea of something for cessation.
I agree with that, because you don't want to stifle innovation and a business moving forward, or a new entrepreneur coming in. That could happen as well.
Okay. I respect Mr. Cummings a great deal, but I disagree on this business of like, well, we need to do it globally, because it's not going to happen globally, and because there's such a distinct difference between by right and by exception. I really think that there's a difference, and what we have in front of us is something which is much more likely to happen than it would in the by right sphere. So I think with this opportunity, I think that it would be important. There are only two changes that I would make to this Amendment 1, or whatever it's called. The first one would be that we can do away with the vesting issues. The law is there, okay? And I'm fairly comfortable that the law clarifies it, and we don't need to get into that. But that the situation really can arise where construction starts and then stops, and then it becomes a problem. And from an advocate of the businesses, we heard the number 2 years, that a pause in construction of 2 years or more, then they must comply with any changes in the code at that point.
2 or 3 years. is what he
Excuse me?
mentioned. 2 or 3 years is what he mentioned.
Yeah, I
He's
know.
saying he's
He-
not really sure.
Well,
2 or
said 2, and then he thought, well, maybe I can get another one for my clients. But personally, I would put it out, you're talking about, after a building permit, you're talking about 2 years, after a pause in so it's been construction for a year and a half, and then it's paused for 2 years. So you can be talking about a pretty significant period of time in which there may or may not be significant changes in the law. Okay? I'm going to throw that out. I don't want to get too complicated with that, but that would be the first thing I would suggest. Do you want to talk about that first?
Well, I mean, I'm okay with this. I think that businesses are not trying, they're not intentionally trying to pause because time is money, right? I fully believe that the vast majority of businesses that are trying to construct something, they're trying to get it done and move on so they can focus their energies on new business. So when there is a pause, it's either, they've run into financial hardship or things have changed about about gaining materials or something like this, financing, something like this, right? So I'm probably okay with this. I think two years is appropriate.
Yeah.
So
And
let
you're
me
talking about it on
But I don't think
top.
they're-
You're talking about it on top of 2 years.
Yeah.
Okay. So
But can I throw out just a scenario there? A hypothetical is, say, construction stops past this point, bunch of changes in the law have happened. You say, okay, now because the construction, this thing passes, now you have to accommodate all of these changes, which essentially kills the project. So
Not necessarily. It could be that they have fewer parking, requirements, and that actually works to their advantage. You can't hold them to the stricter parking requirements.
well, if you say you have to, it can go both ways, but
Yeah, that's what I'm saying, yeah.
Yeah. How often do we reduce things in the city?
Oh, it's happening. We are on the peninsula seeing it happen right now.
Reducing requirements?
Yeah. Or maybe it's a combination.
Anyway, so
Yeah.
getting back to my hypothetical, say there are increased requirements that are just going to be too costly to meet. Basically, construction would just halt forever, and you might have a half-built building that just sits there for years and years and years because nobody can afford to finish it, nobody can afford to tear it down, or something. It just sits.
well,
That to me is the more likely scenario.
Well,
than-
what would happen, we could ask the director what would happen in that case. If a half-built construction site for something doesn't get built and it just lingers, how long does it linger before the Office of Planning and Zoning does something, and what
I
can they
believe
do?
it's 6 months and we can revoke the permit. Or we can revoke the permit if they're failing to progress.
Yeah, so
measured pace.
you revoke the permit, it kills the project, and you get a half-built building that just sits there until somebody decides to buy it, apply for new permits, or tear it down and start over again. But
Well, it's usually-
probably you're going to have something that just remains
it's
like a
usually,
zombie.
I would suggest that it's usually financing problems, and then somebody steps in and buys it at a better price. But one of the biggest examples is Rocky Gorge.
And even
okay.
though that's not a special exception.
It's not a special exception use, but it's an example of something. And the special
Well,
exception uses are going to be smaller.
Rocky Gorge, let's stop bringing up Rocky Gorge. 'Cause
Or, well, how about any of the
it's
zombies? There's
just a different thing.
several around town that are called, we know what they are, we know where they are. They're not being built, they're terrible for the environment because they've taken down all the trees and they're bad for the creeks when all that runoff is now going into the creeks and they're going.
I understand it, but those
unchallenged.
aren't special exceptions.
No, we just said, we acknowledge they're not special exceptions. That's,
Right, and that's another story. I
Okay,
mean,
I've heard.
but
the
changes
council
in the
needs to
buil-
address zombie projects.
Right.
Something
The building
separate than
code
this.
changes, and the only one I could think of was a safety issue, and they happen. And I don't think you could say we're going to just ignore any safety issues or regulations that have changed 4 years after a permit has vested.
Okay. I want to move on to the second point.
Can I, just to, yeah, finish up, I guess the way I see it is that when this is likely to happen is because of financing.
It's
right?
what?
It's because of financing. We both said that.
Yeah.
I think that when if we force them to change the regulations or the minimum whatever that they're building, that only adds to those financial difficulties, right? And to me, if we're trying to avoid a situation where we get a half-built building, the easiest way to do that is to say, once you've committed and you've vested and you've done enough processes, we want you to continue that process. It's not by way of moving the goalposts on them. That's how I view it. And if we do want to make that, and it sounds like the situation like Rocky Gorge not being a special exception, that again, I think that it should be a process that is inclusive of both special exception and the by right, because I think what we're hearing is what we can talk about are the by rights are actually the ones having this problem.
Well, actually, it was a planned development.
Yeah, it wasn't by right.
Okay.
Yeah.
So if the permit is revoked, it would, and a new buyer comes in, they would have to come in with a new plan and a new plan development, which would be great.
Yeah, we need
because-
we need a zombie
Okay.
project law.
Right. And I
Okay.
understand
Whatever.
the difficulty of combining these and
Okay.
to solve the problem.
When we come to voting, we'll vote on this
Yeah.
issue. Okay? Enough said? Enough said. Let me move on to the second point. Second thing I was going to suggest, and this would be under the cessation of special exception use, go down to D2. Okay. The Board of Appeals may grant up to one successive extension of a year, provided that the written request. Period. Next sentence. I'm suggesting adding the next sentence. A use which has ceased for more than 2 years must reapply for a special exception subject to the standards in B4 above. Follow me? So it gives them, if they're not using it for 2 years, then they simply need to reapply to the Board of Appeals. Observation?
So I don't know that you're asking them to reapply for a special exception. You're asking them to request an extension according to the standards set forth in B4.
So we're not making them start all over.
Would that include a public hearing before the Board of Appeals?
Yeah, every time the board has a meeting, it's a public hearing. So
So
yes.
it would be an application for an additional extension of
Yeah,
1
the
year?
application would be for an extension, but this time they'd have to meet that higher standard. It's not just good calls.
Yeah.
I like it.
Okay. Thank you. Okay. Let me read it. We would change it to D2. We would change the 2 years to 1. We would add a sentence. A use which has ceased for more than 2 years must reapply for an additional extension subject to B4 above.
I would agree with that.
Before standards.
Yeah, I think that's good. B4 standards, yeah.
Yep.
Okay. All right. I will now make the motion just because I'm on a roll. I would move that we recommend to the city council that they approve the changes.
Amendment 1.
I guess it's Amendment 1 with first vote, with the addition to B2 that the sentence be added that pauses in construction of more than 2 years must comply with changes in the existing laws. Do I hear a second?
I second that.
Do we need any further discussion? Okay, all in favor of that recommendation to the city council, say aye. Aye. All those not in favor, say nay.
Nay.
Okay, does not pass. And secondly,
No tiebreaker?
that we add to D2, that edit and sentence, a use which has ceased for more than 2 years must apply for an additional extension, subject to the standards. Do I hear a second on that?
Second.
Any further discussion necessary? Thank you. All in favor, say aye.
Aye.
Aye. So that's passes 4-0 now, and just to clean things up, so the vote to recommend passage of this to the city council is, I move that we recommend approval. Second?
Second.
Any further discussion? Very good. All in favor, say aye.
Aye.
Aye. Very good. Now, somebody needs to write the findings. Great. Please include something about our discussion about compliance with the changes in the law, something like that. And it would be really neat to put in a sentence or two about vesting, just so that it becomes clear to people that things don't vest just because the permit issues. They only vest if they've actually done work, okay? And I've got those citation numbers if you want them.
I have them as well.
Okay.
Yep, got them.
Damn, you're
I can add comments.
Jesus
I know everyone's into the writing. I can do it right
All
here
right.
in the document.
We'll be done with it before we leave.
No, we've got some other business to do. We have a number of findings. Where the hell did like agendas go? We have some findings to, oh my God. Okay, we have signature copies. Let's go, let's start with expanding the Daycare Act.
Oh, yes, thank you.
Okay, let's do that. That was passed on July 14th, 2024. The findings have been circulated, and is there any discussion on those findings?
Nope.
Okay. I will move that we approve those findings,
Second.
and all in favor of that, please say aye.
Aye.
Okay. What I'm going to do is sign and pass it around for your signatures. The date is September 5th, right? Diane?
Thank you.
Moving on to the Maritime Industry Economic Development Fund. We, in an in-person meeting, we reviewed all this at length with Mr. Rice. And Mr. Lashinsky was present, and the findings have been circulated. Are there any changes?
Nope.
Got it. One's yours. Is there any discussion on that? Any changes, edits, corrections? I move that we approve. Do I hear a second?
Second.
All in favor, say aye.
Aye.
Okay. Let me give that to Alex. I don't care how we do it. Moving on to the citywide prohibition on new drive-through windows. I would like to say that I can't, what the role that I played in this was, I think, advising a commissioner to include a lot of the staff report, just because the background, it was so well written and it was so sort of complete, and that we agreed with those factual observations, but we did not agree with their recommendation. But that, I included it just because it was, I just thought it was quite accurate and clear. Are there any changes to that? And I will hear a motion to approve the findings on 0624, the prohibition on drive-through windows.
Motion to approve.
A second?
Just as a reminder, I'm abstaining from this issue.
I'll second. Thanks.
And then finally, the findings and decision on Parole Place, which went through several iterations. Has everybody had a good chance to see this? I just point out, this is a quasi-judicial decision, so it's titled as a finding and decision, not just a recommendation to council, okay? So I'm glad that we spent the time that we did and that we got it as clear as we did. Okay. Do we have a motion to approve them?
So moved.
Second?
Second.
Okay. All in favor, say aye.
Aye.
That's approved. Wait a minute. Did I just get this?
Looking forward to seeing that start construction. Get rid of the invasive species.
All right, under new business. I want to thank all of you who did the work on these findings, that took time out of your summer to do them, and although they're not formatted to Mr. Plein's standards, I think the contents are really very good. I think they're very explanatory. If anybody in the council takes the time to read them, I think that they'll be informed. And talking about findings, I thought that when we went through with, especially on Parole Place, but I've seen it happening more and more, is that somebody will draft these things, and they get sent around for everybody to look at them, and people will make edits. And then that requires another, typing in another circulation, and then somebody else will make an edit. Not a comment, but an edit, which requires then everything to get recirculated. And I don't think that, that's not efficient. Sir?
Yes, so I sent you an email about 5 o'clock this afternoon, so you may not have seen it yet, giving a proposal for a solution, and that is for us to move to Google Docs and a Google Drive. So I've uploaded everything from today into a Google Drive for us. I've sent it to you. I can add you to if you want, but the idea was as a pilot, if you want to check it out, this, by using a Google folder, Google Drive folder, and then Google Docs, it will allow us all to be able to interact on the same document, not have version control issues, be able to make changes live, comments as well as in-text edits. So you can do all this, right?
No in-text edits.
No intent, well,
See, because that makes it, that's a problem.
okay, so we can remove that aspect. That's okay.
But
All
the
these
comments
things-
are great.
Okay,
And everybody can see everybody else's comments.
correct.
And then it goes back to whoever drafted.
So it's live, so anyone would pull it up off of Google Docs and be able to see everything. So you don't have to circulate it, it's just accessible.
Okay, and then there should be a cutoff time.
Yep.
When it goes back to the drafter to come up with a final draft.
Okay,
And to incorporate whatever comments that drafter thinks are appropriate or not. And then those that he or she discards can be up for discussion.
Yep.
Okay, and then we can,
And I would propose that we either get together in person and put a document up and go through some role play, or we can do something like that via Zoom,
Yeah.
would work too. But I think we all need to do that we need to do it synchronously so we all are on the same page for how that works.
Yeah, and if people want, I can lead that effort, so that way
Sure.
everyone understands exactly how this works. It's a very easy process, I think, once you learn, right?
Yeah.
We do this in my full-time job. We do it though through SharePoint documents, but that costs money. Google Docs and Google Drive are free, so that allows us to be able to do the same exact thing without costing the city any money.
Okay, that sounds good.
Yep.
Chris, do we have, what kind of an agenda do we have for next time? Do you have any
Just
ideas?
getting ready to mention to you.
Oh. He's getting ready to mention to me?
I was.
Oh,
Does anybody have anything? Because we don't, for October 3rd,
yeah.
nothing is there.
We, speaking on behalf of the department, we would not want you to miss the opportunity to meet with us again in October. And we will have content for you because we are moving into comprehensive rezoning. That means modifying the zoning map to make it comply with as closely as possible with the adopted land use plan and the comp plan. And we're assembling a whole set of text amendments that are very complicated and broad reaching, and we're spending time trying to manage that to get into tranches that we can bring to the approval process. But we want that to begin with you. We want you engaged in the beginning because the comp plan is something you adopted and comprehensive rezoning is something that is initiated by your efforts. So,
Okay.
but we like to do that in October, and we don't know what else might come up before then.
Would October 3rd, 15 to 30 minutes be adequate?
It would. Yeah.
Okay, so keep that in mind, that we would like to spend about 15 to 30 minutes making sure that we all understand this, and then we can work with this. I think it's going to be simple. I'm probably the one.
Oh, yeah, this thing. Yeah, sure.
Yeah, okay.
Oh, you mean this
Google
meeting,
Docs.
the process of,
We're going to put that on the agenda.
Yeah, put it on as a reminder.
To work
That
with
sounds
Google
great.
Docs we don't have to do that in the meeting.
Well,
Frankly, it would be better if we did it offline.
yeah, yeah.
well, we'll do it after the meeting, because it's just a kind of a work session.
Whatever.
I mean,
Yeah.
it can be today after the meeting too. It's up to y'all.
Oh, what time is it? 8:45. I'm game.
Make sure your mic is on, though. I think.
Apologies. It could be today after the meeting as
All right,
well. So
good.
yeah,
All right.
It should not take very long, but I would be able
I'm
to
a
answer
heavy
any questions.
Google Docs user, so I
Yeah,
don't need
yeah, you know.
All right,
there, but-
is there anything else?
So we will be meeting for
October
Thursday and
3rd.
October for something in November.
And certainly November. As I was just announcing our intention to bring information to you in October, I just remembered that both Eric Lashinsky and myself will be traveling with the mayor in a multi-jurisdictional delegation to Sweden on that day. So I don't know that we're going to be able to Zoom into a planning commission meeting from Sweden, although there's a possibility.
Oh, you do?
Which is to say that I probably spoke too fast. And I'm sorry about that, but perhaps there's a possibility for another meeting before then or shortly after. Even if it is your normal virtual meeting, we could join in and so we wouldn't have to skip an entire month.
I mean, I'm around, I'm going September 20th through 25th. Other than that, I'm all yours, okay?
Okay. So let's,
When are you leaving for Sweden, sir?
the 30th of September,
Okay.
29th,
That
30th.
last week of September
Yeah,
might be.
Yeah, as an example,
a
might-
decent
that-
week to replace the October 3rd meeting?
it would be, it might very well be. It would
the
work
second-
for us.
Okay.
The second week in September, the 19th, is typically the second Thursday, the third Thursday we have marked as a possible virtual meeting. I mean, that's a possibility.
If you only
The
want to be
19th?
virtually.
I'm gonna be,
we can work through the Kimberly and get dates out to the members
Okay.
that work.
Why Sweden?
We're visiting Stockholm and understanding sustainable development, mobility solutions that are working there that they have established some precedent with, and some green environmental planning as well. Would hopefully bring back some ideas and some models for development that have worked in other countries, other cities.
Anything further? Do I hear a motion to adjourn?
So move.
Second?
All in favor, say. Aye. Done.
Okay.
Yeah, you'll just have to. Yeah, something. Yeah, I mean, you're not.